Well, hello. I'm Irene De Jesus.
And I'm Hector De Jesus.
And we are the De Jesus Law Group.
Yep.
And this is the Noon Show.
Because it's noon somewhere in the world.
Yes. And so it is Easter weekend. Anyone that celebrates Easter, happy Easter. This is Good Friday. So we'll have a nice quick show today, but I think it'll be really good. Do you want to do our disclaimer?
Yes, we are attorneys.
Okay.
However, we're not necessarily your attorneys. However, that can be remedied if you want to give us a call. But this is informational and educational purposes only.
Yes. And so today we're going to be talking about what are some potential problems that you could face if you have a trust. And we're actually going to do 9 of them. We're going to talk about 9 potential problems. Before we get into that, though, we're into April, right? This is April. Woohoo! We just passed April Fool's Day. Did you have anything happen to you yesterday? Yeah, I didn't either. So that was good. Yay. We did our Wine and Wills on Wednesday. That was really good. Rebecca Jones, she hosted it for us here in DeLand at her office space, and it was beautiful. We had so much fun. Val with Scout and Cellar, she did the wine tasting afterwards, and it was really, really good. So we'll be planning more of those this month. We'll let you guys know when we're going to be doing them. Yep. And then, as usual, for the month of April, we do have a great offer. If you book a legal life planning session, basically, we've got some stuff to give away to you, some freebies, and you'll get that session at no charge if you do some homework, right? What's a legal life planning session?
That's about a 2-hour meeting where you get to sit with us, you do the homework, which allows us to really get an idea of what it is that you want to do. We utilize your numbers and your data, and we point out any gaps, any opportunities, and give you options.
Yeah. And so one of those things we'll do is that if you already have a current plan in place, so you've got some kind of estate plan in place, so that if something happens to you, whether that's incapacity or you pass away, one of those things we'll do if you've already got a plan is we'll review your plan with you. Because we find most people have no idea what their current plan does or even says. It feels just too complex for them. So that's part of that 2-hour review, is looking at what do you have and what will really happen. And we walk you through it. We love what we do. Producer Wynn, she will have links in the comment box for you to be able to get information on that legal life planning session if you want. She'll have links to get to the website. She's great. She's amazing. She'll have all of that there. She'll probably also have a link to these 9 potential issues that you can have if you do have a trust that we're about to go over. So you ready? Should we get started?
Yep.
Boom. All right, let's do it. Do you want to do number 1?
Number 1 is, do you have the right successor trustee? And what that means is typically when you do a trust, most people do a revocable living trust, whereby the person who does the trust is also the trustee.
Yes.
As well. But what you want to have is what happens if you become incapacitated or die, who's going to step in?
Right. And the person that you originally named to take over for you in case something happens to you, is that still the same person? Is that still the right person to have in that place? Right. So a lot of times we see plans are older, right? And a lot of things have happened in your family. They've happened, and your plans don't reflect that.
I just had a client who I did a trust for 2 years ago, and the person that she had as a successor trustee had a stroke last year.
Oh.
So we ended up having to look at it, amend the trust, and put another successor trustee in there because she physically couldn't do it anymore.
Yep, exactly.
Yeah.
So there's lots of things that can happen with that first one. Do you have the right successor trustees?
And that's one of the things in the legal life planning session. If you do work with us when we're doing the design, we walk through, who would be a good fit and why. And most of the time when someone says, I'd like this person to be, I always ask, well, why is that? And
let's make sure
yeah,
you're
let's
the
make
right
sure-
person for you and your situation.
Right.
All right. Number 2 potential problem is who in your documents, who does it say can remove the trustees?
Mhm.
And is that even possible, right? Does it say that in your document? Can the heirs that are in the document, the beneficiaries, do they have the right to remove the trustees? And so when we think about what is a trustee is somebody who manages the assets that are owned in the name of the trust. They manage them for the benefit of the beneficiaries. And sometimes, hopefully it's a long time before you pass away. Sometimes things happen that you aren't aware of, right? And maybe there's going to be some conflict with the original trustee that you picked. Can those beneficiaries get together and remove them? And do you even actually want that to happen? So that's part of what we'll go through with you.
Right.
What's number 3, Hector?
Number 3 is, can your spouse change the ultimate distribution of the trust assets after you've passed away?
Ooh, that's a good one.
That's a good one. And I'm actually dealing with the trust administration right now where the gentleman passed. And there are several things that you can do when you're designing the trust. And you can make it easy as, when I pass, then my spouse can do whatever she wants or he wants with the assets. And that sometimes is
it's a
beneficial.
good thing. It's a great thing.
But sometimes it's not.
Blended family, right?
If you have blended families, if I were to pass and I had a child from another marriage, it's real easy if I just say my spouse can do whatever for that child to get
left out.
So sometimes in a blended family, or sometimes the family dynamics are such that you want to make sure that things are kind of going to go the way you wanted it to when you designed it.
So that it doesn't matter who passes away first, that both sides that have children, they're protected. The kids are protected, right?
Yep.
Okay, number 4. Number 4 is, does your trust protect the children and grandchildren from lawsuits and divorce? That is a big thing that we deal with when we're looking at with you. Is that important to you? Is that something that your family might need? Or does everything just go outright to your beneficiaries, to the kids and to the grandkids? You'll know as we walk you through it, does that make sense for your family or doesn't it? But that is a really cool option, right?
Yeah.
Is give that kind of protection. Do your kids, I know for me, seriously, I'll just be totally transparent here. If I would have inherited money when I was 18, pretty sure I would not have gone to nursing school. Pretty darn sure. Yep. It's TMI. All right. So number 5.
Have you funded your trust yet? That should be number 1. Yeah.
That should be number 1 as the potential issues with a trust.
So when you do a trust, if you don't fund it, which basically means put stuff into the trust, if you don't do that, then you don't really have a trust.
Okay, so listen, most people think that as soon as you get this document signed, that somehow magically all of your assets are now titled in the name of your trust.
And
they're not.
Yeah.
Yes.
We've had several clients or several people reach out to us in the last few weeks, and I've heard the same thing.
Yeah, we reviewed their trust plan with them in that legal life planning session. And we asked them, so have you retitled your assets in the name of the trust? And they're like, what?
Yeah.
I have a trust. What do you mean? Oh, no. There's work to be done.
Yeah.
So that's part of, what we do is really helping you and guiding you on, this is a critical aspect.
It's a big aspect, especially if you have a business. If you're a business owner, you want to make sure that your business is in the trust so that if you are incapacitated or passed, there are things in place.
No, it's actually not that complicated to do. It really isn't. It's just the fact that you need to get it done.
Right.
All right. What are we at? Number 6.
Number 6.
What's that one, Hector?
Who is named as beneficiary of your retirement plans other than investments?
Ooh, that's a good one.
And other investments.
Right.
Oh my God, I can't read it.
All right. So this is something that comes up often when we're working with our clients. We do that planning session and then their documents become legal.
Mhm.
Then we sit with them and we go through each and every asset line by line. And we walk through, what is it that you want to happen when you pass away? How do you want this asset to go to your beneficiaries? And sometimes it makes sense for that asset to just go outright to your spouse, right? You list your spouse as the primary. Sometimes, though, it doesn't make sense to do that. With a trust, sometimes it really makes good sense that it actually goes to the trust first as the beneficiary. So that there's a lot of things that can happen to do that. One of them is so that the assets are protected, right? For the kids and the grandkids. It's there's specialized things that need to be done, but that's what we do, right? That's part of what we do when we put that trust in place.
Yep.
All right. Number 7.
Number 7.
At what age will children inherit? When will they receive that? At what age? So you have an option when you've got your trust plan, right, of when you want them to receive.
Right. We call it ages and stages. And it really depends, because some kids, and I'll say kids, if they're 21, 24, are very mature and responsible, and others at 35, 45 aren't. So you would know your children and maybe you or grandchildren, and you might want to put ages and stages. I want them to be co-trustee at this age. I want them to be sole trustee at this age. It really depends. So that's one of those things.
So let's step back a bit. We just threw some legal jargon in there. So when we're saying they can be a co-trustee, what that means is maybe when the kids are in their 20s, it would be great to have somebody else who can give them financial guidance when you're not here.
Right.
Okay. So you're gone, and they can then walk your kids through decision-making processes so that, one, your kids get the experience of learning how to manage the assets that are in the trust for them. And 2, they've got the guidance built in so that they will make good decisions, right? And then maybe there's a stage where you're going, okay, now I feel like at this age, they really should have everything together. Let's allow them to be the sole trustee now that's managing those assets for them. Do you have that in your documents? That is one of the things to look at, right?
Right.
What's 8?
All right. 8 is, does your trust have provisions providing for maximum tax deferral if it is named the beneficiary of a retirement plan?
Ooh. All right. So we had lots of changes, right? January 1 of 2020, that was when the Secure Act took effect, which really, really impacted retirement plans and how they can be passed on. So you're going to want to look at your trust to see, have you had that updated since the Secure Act? Right? Because that's a really big thing. Part of what we do in our firm is we follow up with our clients. Sometimes it's every 3 years if that's what they want, or sometimes it's yearly. Especially when there's changes, though, we're letting them know this is what's happened, and let's review what it is you want to happen when you're not here. How do you want your beneficiaries to receive those assets, that money? So really, really big deal on that one, because you are dealing with a lot of tax consequences on the retirement accounts. Something to keep in mind. All right, next one.
The last one.
This is number 9. Okay, number 9. Is your trust up to date for estate tax purposes?
And boy, this is timely. Right now there are proposed changes that are being discussed with respect to the estate tax, going from $11.7 million exemption per person to possibly 1 to 3. And that's a huge jump in the tax rate, going from 40% to possibly 50%. Which is another huge point. And then there's possible eliminating the step up in basis or basis, and
which means capital gains.
Capital
Yeah.
gains.
So when you pass away, when both, if it's you and a spouse, when both of you pass away, what will it look like for estate taxes? So yes, when you die, the government wants its due, right? They want their taxes. And if you're a married couple, that doesn't happen at the first passing. It happens at the second passing, when the second spouse passes. So what are the taxes that are due? And what we look at with you is, the house. Say you have a home that's been your residence, and now your kids are going to inherit it. Well, they have to pay capital gains. And so that's some of the changes that are being proposed. We don't have a crystal ball. We don't even pretend that we've got a crystal ball. But the discussions that have been going on in the administration, the government, is likely the changes will take effect January 1. If that is the case, you are definitely going to want to, if you have already have a plan in place, you're going to want to have your attorney or our firm review that plan to see what's going to happen and how are you going to be affected with those estate taxes.
Yeah, and and a general rule of thumb, or good rule of thumb, is if you have a plan that's over 5 years old, you should just have it reviewed.
Yeah.
At the minimum. Or if you move from another state, in Florida, we have a lot of folks that come from various states down to Florida.
You know what? It used to be felt like they were coming from north, right?
Yeah. They're coming.
We heard they're coming from California.
Yeah, there are a lot. But either way, what you want to make sure is if you do decide to make Florida your home state, and your trust or your estate planning was done somewhere else, it's always good to just get it checked to make sure it comports with, or if there are any changes that are coming down the pipe, that what you have currently in place will still suffice.
Yeah, because we in Florida, some of our laws and that we have that are state specific are different than from where you're coming from. And if this is now going to be, Florida is now going to be your new residence, right? This is where you have an intent to stay. So what does that mean? Well, you get a Florida driver's license. You get voting registration, right? Things like that show that you have an intent to reside in this state. Well, then this state, it has a vested interest in making sure that when you pass away, its laws apply when you pass away. So you'll want to get it reviewed for that. So those were the 9 potential problems that you can have if you have a trust in place. Part of what we do is review your plans with you in that legal life planning session. Wynn will make sure she's got all kinds of links in the comment box. If you've got any questions, we'd love to hear them. Other than that, this is Good Friday, and we're done for the rest of the day, right?
Yep.
We're about to go enjoy ourselves. Oh, we've got a question. What does it say? Irene and Hector are so knowledgeable. Oh, fantastic advice. You and your family will be in great hands with them. Oh, thank you so much, Natalia. You are so sweet. Really appreciate that, my dear. All right, for all of you that are celebrating the Easter weekend, go enjoy, have a great weekend. If you're not celebrating still, take the weekend off, enjoy, rejuvenate, connect with family and friends. That's what we're going to be doing. And that's it. We're about to say goodbye.
Go Cubs.
Go Tigers.